Welcome to Do It for the Case Law, Wednesday, August the 5th, 2026. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Today's docket features 62 federal appellate opinions across 7 circuits. We will cover civil rights litigation, including Section 1983 claims and employment discrimination constitutional challenges involving habeas corpus, taking, search, and seizure, and the First Amendment criminal justice matters ranging from sentencing guidelines to drug trafficking and firearms offenses, business and labor disputes, including securities, bankruptcy and insurance cases, and immigration appeals alongside environmental regulatory reviews. Subscribe for your daily briefing on federal appellate law. Do It for the Case Law is a news reporting service. We summarize and discuss federal appellate opinions. Nothing in this broadcast constitutes legal advice. Let's turn to James covering criminal justice.
Thanks, David. Today I have 16 cases from 6 circuits. The disposition roll-up is 8 affirmances, 5 dismissals, 1 vacatur and remand on sentencing, 1 vacatur and remand for a new trial, 1 reversal and remand on a supervised release condition, and 1 split outcome where the court affirmed in part and reversed in part. Starting with the 11th Circuit, the court vacated Marcus Telfair's sentence and remanded for resentencing because the district court erred by refusing to apply the federal kidnapping guideline as the most analogous offense. The panel held that the cross-reference provision regarding possessing a firearm in connection with another offense unambiguously applies to state offenses, not just federal ones. Moving to the 4th Circuit, the court issued a split outcome for Christopher Park, affirming his conviction and sentence but dismissing the appeal due to a valid waiver. While the waiver barred challenges to the substantive reasonableness of his 180-month sentence, the court clarified that it does not preclude colorable challenges to the plea itself, though none were preserved here. Over in the 7th Circuit, the panel reversed and remanded Sean Pena's case regarding a supervised release condition. The court vacated Special Condition 13 for being too vague but affirmed the 24-month revocation sentence, finding the district court properly considered police reports on dismissed theft violations. The 9th Circuit also issued a significant reversal, vacating John Chapman's kidnapping conviction and remanding for a new trial due to impermissible jury coercion. The court identified that the district court gave an Allen charge without disclosing it had received jury communications, violating the totality of the circumstances standard. Regarding remaining appeals, the 11th Circuit dismissed appeals in 3 cases. Logan Mertlich's appeal was found frivolous under Anders. Jerome Kigundu's challenges were barred by law of the case, and Michael Kersey's sentencing disparity claim was barred by an enforceable plea waiver. Anthony Mobley's appeal was also dismissed as moot after he completed his sentence. The 4th Circuit affirmed Darrell Smith's 120-month sentence for distributing cocaine base, finding no plain error in the government characterizing his criminal history as understated during advocacy. Randy Price's Second Amendment challenges to his firearm convictions were foreclosed by binding precedent regarding felon in possession statutes. In the 7th Circuit, the court affirmed Miguel Morales Garcia's drug conspiracy conviction despite reversible error admitting prior heroin evidence, ruling the mistake harmless given the overwhelming proof of guilt. The 8th Circuit affirmed LaTroy Curry's fraud and money laundering sentences, rejecting the argument that intended loss calculations were improper under current commentary. Todd Sutton Jr.'s motion to suppress a strip search was also denied under the Florence standard for facility safety. Finally, in the 9th Circuit, the court affirmed supervised release conditions for Davidovich and Thomas prohibiting residence near schools and parks, finding the restrictions reasonably related to public protection given their histories involving minors. Davidovich failed to object to the specific direct view formulation, while Thomas received a sufficient explanation for the 2,000 feet restriction. Back to you, David.
Thanks, James. Let's turn to Aisha for the civil rights docket.
Thanks, David. 15 cases today across the civil rights beat. The disposition roll-up shows 8 affirmed, 3 dismissed, 1 split outcome, and 2 vacated with remands. Leading with the movements in the 11th Circuit, the court reversed summary judgment on Title VII claims against Dynamic Security and vacated a retaliation verdict for a new trial in DeVita Key versus Hyundai Engineering America. The same panel also vacated a dismissal with prejudice in Michelle Maupin versus School Board of Miami-Dade County, finding the sanction too harsh for isolated mistakes. In the 4th Circuit, the court vacated summary judgment on an ADA accommodation claim in Ibrahima Dieng versus Orkin LLC, ruling that indefinite unpaid leave is not reasonable when reassignment is possible. Moving to the 9th Circuit, the court affirmed a denial of arbitration in Rickes versus Thermo Fisher Scientific, holding silence does not constitute assent to a dispute agreement. In the 10th Circuit, the court affirmed dismissal of a Section 1983 suit against a state judge in Fitzsimmons v. O'Hara, finding sovereign immunity barred the claim and Ex parte Young did not apply. The same circuit also affirmed summary judgment for Westlake Services on a Truth in Lending Act claim in Thigpen v. Westlake Services, ruling the suit was time-barred. In the 11th Circuit, the court affirmed denial of a preliminary injunction but reversed dismissal for lack of standing regarding 2 students in the Cobb County School District case, holding past harm supports damage damages and ongoing injury supports injunctive relief. The same circuit also affirmed dismissal of Zbmudichors versus Secretary of the Treasury for failing to allege a severe hostile work environment. In the Fourth Circuit, the court affirmed dismissal of Brian Wardell versus Pitt County for failure to plead plausible facts regarding his termination, and affirmed summary judgment for Herbalife in Cameron Eikens versus Herbalife International on discrimination claims. The Seventh Circuit affirmed summary judgment for the City of Madison in DuPont Water Company versus City of Madison, ruling the water company failed the physical capability test. In the Eighth Circuit, the court dismissed Officer Koster's interlocutory appeal in Thomas Riles versus Carroll County, finding no jurisdiction to reweigh credibility on qualified immunity. Finally, in the Ninth Circuit, the court affirmed dismissal of Abdul Fattah El-Awendi versus Driscoll on res judicata grounds and for lack of jurisdiction under the Whistleblower Protection Act, and affirmed summary judgment on qualified immunity in Kelly Altiero versus County of Spokane regarding an animal protection officer search. Back to you, David.
Thanks, Aisha. Let's turn to Michael covering constitutional law and prisoner rights.
Thanks, David. We have 6 substantive opinions today from the federal circuits. The disposition roll-up is 1 dismissal, 1 denial, 1 affirmation with a remand, 2 affirmances, and 1 vacatur with a remand. Leading with the non-routine outcomes, the Sixth Circuit vacated an attorney fee award and remanded for reduction, finding the original order an abuse of discretion under the lodestar method because counsel billed 573 hours litigating failed class certification motions and other non-compensable work. The same court also split its ruling in a Fourth Amendment excessive force case involving a trooper and a suspect holding a child. It affirmed the denial of qualified immunity while remanding for further proceedings, holding that the armbar takedown violated clearly established law since the suspect posed no immediate threat. Moving to the Tenth Circuit, the court denied Ivan Kels's application for a certificate of appealability on his Section 2254 habeas petition, dismissing the appeal because he waived evidentiary claims by raising them for the first time in his brief. In the Seventh Circuit, the court affirmed the denial of qualified immunity to a town chairman who engaged in viewpoint discrimination on an official municipal website, ruling that such conduct violated clearly established First Amendment law in 2022. The Sixth Circuit also affirmed the dismissal of Dr. Mark Charlton Perkins' Title IX and Section 1983 claims against the University of Cincinnati because he was not physically present in the United States when the job search was canceled. Finally, the Ninth Circuit affirmed Adriano Lepo's conviction for aggravated sexual abuse, upholding the admission of prior bad acts evidence under Federal Rules of Evidence 104 and 413. Back to you, David.
Thanks, Michael. Let's turn to Maria covering business and civil matters.
Thanks, David. Maria Santos with 17 cases from the 11th, 4th, 6th, 7th, and 9th circuits. The disposition mix here is 4 affirmances, 2 split outcomes, 3 vacators with remands, 1 reversal with a remand, and 7 denials or dismissals that are routine, plus 1 other mixed ruling. Starting in the 11th Circuit, the court reversed the district court's dismissal in Jasma Hall versus Ally Financial. The lower court had correctly found Hall lacked standing because she wasn't a party to the contracts, but had applied the wrong remedy. When a federal court lacks subject matter jurisdiction due to standing in a removed case, it must remand to state court rather than dismiss without prejudice. So this case returns to Georgia Superior Court for further proceedings. In a related Fourth Circuit matter, the court affirmed the dismissal of 2 adversary proceedings filed by Elshan and Babak Bayramov against American Credit Acceptance. The plaintiffs lacked standing in their personal capacities because the injuries belonged to the LLC they owned, not them individually. The court clarified that claim ownership is a merits issue, not a jurisdictional one under Virginia law. Moving to the Sixth Circuit, the court reversed the denial of a motion to remand and sent the case back to state court because the defendant's second removal attempt was untimely. The 30-day deadline for removal is a strict requirement that cannot be equitably tolled, even if a prior remand order created ambiguity.
Over in the Seventh Circuit, the court split its judgment in Cameron Eikens versus Herbalife International of America. While affirming the insurer's victory on penalties under Section 155 of the Illinois Insurance Code, the court reversed the lower court's judgment for the insureds regarding breach of contract and declaratory relief. The holding establishes that an insured is entitled to independent counsel at the insurer's expense only when there is a serious actual conflict of interest between the insurer and the insured, not merely based on adverse interest between co-defendants or a temporary reservation of rights. In the Ninth Circuit, the court split its ruling in LifeVoxel Virginia versus LifeVoxel.ai. It affirmed the dismissal of securities fraud claims for failing to plead economic loss and loss causation, but reversed the denial of leave to amend the complaint because the court also vacated and remanded Youssef versus Great American Life Insurance Company twice, clarifying that a district court cannot order a remand based on equitable jurisdiction without first allowing the removing defendant an opportunity to waive the adequate remedy at law defense to retain the case in federal court. Additionally, Ford versus St. Charles Health System was vacated and remanded because the plaintiff's state law claims regarding meal periods were not preempted by Section 301 of the Labor Management Relations Act, meaning there was no federal question jurisdiction after removal. Finally, Bustos Alonso versus Blanche resulted in a mixed ruling where the court granted asylum and withholding of removal but denied Convention Against Torture relief. The petitioner's previous convictions for domestic violence no longer bar asylum following an en banc decision overruling that precedent and a state court vacatur of those convictions. Routine affirmances include Quick Dispense versus Vitality Food Service, which failed to state a claim for breach of an implied contract under California law, and the 11th Circuit's affirmation of Augustus Romaine's conspiracy convictions as foreign agents. Back to you, David.
Thanks, Maria. Raj has the Immigration and Government Roundup.
Thanks, David. We have 8 cases from the 4th and 9th Circuits today. The disposition mix includes 1 affirmed in part and vacated, 1 remanded, 1 affirmed in part and reversed, and 5 denials or dismissals. Leading with the split outcomes, the 4th Circuit affirmed Title Max of South Carolina's claims challenging an ongoing Pennsylvania administrative enforcement proceeding under the Younger Abstention Doctrine, and affirmed the dismissal of its challenge to a separate investigative subpoena on ripeness grounds, but vacated the lower court's designation of those subpoena claims as dismissed with prejudice. The court held that federal courts must abstain because the state proceeding falls within the quasi-criminal civil enforcement category established in Sprint Communications, Inc. versus Jacobs, finding it was an ongoing judicial-style administrative hearing initiated by a formal order to show cause implicating Pennsylvania's important interests. Moving to the 9th Circuit, the panel remanded Committee for a Better Arvin against the Environmental Protection Agency after holding that the agency exceeded its statutory authority when it approved a California state implementation plan that included a feasibility exemption for contingency measures under Section 172 of the Clean Air Act. Applying the standard of review from Loper Bright Enterprises versus Raimondo, the court concluded Congress did not expressly provide for such an exemption in that specific section, since other provisions explicitly reference feasibility considerations while this one remains silent. Also in the 9th Circuit, the panel affirmed the denial of a motion to dismiss for lack of jurisdiction but reversed the denial of a motion for a new trial and remanded Inland Empire Waterkeeper versus Corona Clay Company regarding Clean Water Act coverage. The court held that whether a waterway qualifies as a water of the United States is a merits question regarding statutory coverage rather than a prerequisite for federal subject matter jurisdiction, allowing the district court to retain jurisdiction despite challenges to the creek's status. However, the panel ruled that the Supreme Court's decision in Sackett versus EPA, which narrowed the definition of waters of the United States to only relatively permanent bodies with a continuous surface connection to navigable waters, constituted an intervening change in law warranting relief under Federal Rule of Civil Procedure 54. Turning to immigration denials, the 9th Circuit denied Chuan and Chen's petition for review of a Board of Immigration Appeals order affirming the denial of his asylum and withholding of removal claims. The court found substantial evidence supported the BIA's determination that Chen's experiences in China did not constitute past persecution as he failed to establish that fines paid for violating the one-child policy resulted in substantial economic disadvantage or that he suffered physical harm, arrest, or detention. Furthermore, the court found his fear of future persecution not objectively reasonable because he is no longer in violation of current population control policies and has not shown a reasonable possibility that Chinese authorities will forcibly sterilize him or his wife. The 9th Circuit also dismissed Valentin Herrera and Teresa Najera's petition for review regarding the denial of their motion to reopen, upholding the BIA's conclusion that they failed to establish prima facie eligibility for asylum, withholding of removal, or protection under the Convention Against Torture. The court reasoned their claims relied on general conditions of crime and violence in Mexico rather than specific evidence of persecution on account of a protected ground, finding that fear of harassment by criminals motivated by theft or random gang violence lacks the required nexus to a protected ground. Rohit's petition for review was similarly denied after the court found substantial evidence supported the agency's adverse credibility determination due to material inconsistencies between his application and hearing testimony concerning the affiliation of his attackers, omissions in his written materials regarding threats by police and travel to Dubai, and his voluntary return to India prior to fleeing. Finally, the 9th Circuit denied Zazio Zajradara's petition for review of an Office of the Chief Administrative Hearing Officer order dismissing his citizenship status discrimination claim under Section 1324 of the Immigration and Nationality Act. The court held that the administrative law judge properly dismissed the claim as a matter of law because the employer, Taga Inc., employed fewer than 3 people at all relevant times, falling outside the statutory coverage threshold, and found the employer submitted undisputed affidavits establishing it had no more than 2 employees. Back to you, David.
That wraps our coverage for Wednesday, August 5th, 2026. Today we heard from James Taylor covering 16 cases, Aisha Johnson with 15, Michael Reeves on 6, Maria Santos presenting 17, and Raj Patel handling 8. The day saw 39 affirmances, 9 dismissals, and 14 other dispositions, including reversals, vacators, and remands. Our most significant developments involve several decisions reversed or sent back for further proceedings, signaling substantive shifts in the law across the circuits. A number of cases were dismissed on procedural grounds. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Do It for the Case Law is a news reporting service. We summarize and discuss published federal appellate opinions. Nothing in this broadcast constitutes legal advice. We are not lawyers. If you need legal counsel, consult a licensed attorney in your jurisdiction. Subscribe and follow for tomorrow's briefing.